Hello everyone, welcome to this edition of ABiQ and GIFS webinar series on project financing. Today I'd like to introduce our esteemed speaker, Mufti Ismail, to go through the presentation that he has prepared. So I'm just going to share my screen and enjoy the session. Thank you very much. Thanks. Can you see your presentation?
Yes.
Perfect.
Thank you very much, Dave. Bismillahir Rahmanir Rahim. Nahmaduhu wa nusalli wa nusallimu ala rasulihil karim amma ba'd. Firstly, I would like to thank the esteemed management of ABiQ and you, the esteemed participants, for attending this special program on Islamic inheritance, wills, estates, and fiduciary planning. Today's discussion will cover a brief introduction from an Islamic perspective in terms of the laws of inheritance. We will also cover some of the technical aspects around certain contemporary issues, such as the purchase of a life policy, a bequest, a wasiyah, a bequest of a usufruct or a manfa in Sharia. We'll also discuss the issue of an illegitimate child in terms of whether they inherit or not, and also what happens in the instance if there are no heirs from a Sharia perspective. So without further ado, I would like to move to the next slide. Next slide. Next slide. So these are some of our credentials in terms of the different entities that we've advised in the past. Next slide. These are some of the Islamic financial products that we've developed. Next slide. Next slide. These are some of the Sharia auditing and advisory services that we provide in terms of ensuring a holistic, wholesome service from a Sharia perspective. Next slide. Our motto essentially is embracing Islamic finance through Sharia compliance, achieving new heights in expansion and growth. Next slide. So now let's go into an introduction to Islamic fiduciary planning. What is Islamic fiduciary planning and what does it entail? So the topic of today's discussion is in terms of how do we ensure that we have a proper fiduciary plan in terms of our financial affairs. So an estate is made up of the following fundamentals. It is made up of succession planning. So succession planning refers to if a person has assets, whether they be physical or whether they be of an intellectual nature, then those assets will be succeeded in the event of the death of the owner or the possessor of those assets. And succession planning should be done according to Sharia in terms of how assets and wealth is transferred over from a Sharia perspective. Second is in terms of risk management. When we talk of risk management, we essentially talk of how the assets are protected in terms of the transfer of wealth from one individual to the next. Not only in terms of the transfer of wealth, but also in terms of how the assets are protected themselves. If, for example, the owner built up a huge empire in the form of business assets, etc., how does the owner ensure that his wealth, his estate, and his empire is protected beyond his death? So this is a very important aspect. What we often find is that various estates, various empires are built up, wealthy empires are built up, but after the death of that individual, then we find that the entire empire crashes to the ground. This is extremely sad, unfortunate, and not in line with Sharia. According to Sharia, wealth should be preserved and preserved in a proper manner. Thirdly is in terms of minimizing death costs. So we know that, for example, in South Africa, when a person passes on, then there are certain death taxes that kick in. Globally, there are also different death taxes or costs involved. And if this is not managed properly and in an effective tax efficient manner, then a large portion of the estate could be dissolved due to taxes, or the estate could be reduced. I have seen instances where almost 50% of an entire estate was reduced due to improper tax planning. So tax planning is extremely important in ensuring that the underlying structure of the wealth transfer in a succession plan from a Sharia perspective is also tax efficient. Lastly is in terms of communication. Communication is an extremely important aspect of an estate plan, and the rationale behind this is that what we often find is that the estate plan is not communicated directly to the heirs. There is one executor that is appointed, or maybe two executors that are appointed, and they are not efficiently appointed in the sense that there are no proper signatures, there is no proper executorship, and there is general lack of professionalism in terms of how the matter of an estate is handled. Now, you take your entire life to build up assets, to build up wealth, but yet you can't communicate properly in terms of how the wealth is transferred. So it doesn't make sense, and there should be a proper communication plan or a structure in place in terms of how wealth is transferred across. What are the benefits of proper estate planning? One would ask that why do we need estate planning? So the answer is that an estate plan is in place to ensure that everything is properly reviewed and put according to the correct structure. So if, for example, if you have an estate plan in place, then the estate plan should be structured in a proper way in which all of the matters can be regularly reviewed. What tends to happen is, in certain instances, an estate plan could be out of sync with the current laws and regulations of succession planning and fiduciary duties according to the law of the land. And if your estate plan is not in line with the law, it could become a problem later on. Secondly, is that the matter of wealth creation is a matter also that relates to your own family. You work hard to empower your own family, only to find that if you leave suddenly, if you leave this world suddenly, then you have an issue in terms of how you've transferred your wealth over to your own family. So it's important to communicate the right plan to the family so that they also understand what is required of them also. Thirdly is that you need to have a proper understanding of the Islamic guidelines around estate planning, etc. If you don't have a proper understanding, you could document a totally non-Sharia compliant will that is not in sync with Sharia. And then instead of the wealth becoming a boon for your family, it becomes a curse unto them. And we find many instances of this where things are not documented properly, matters are not accorded correctly, and then it becomes a problem later on. And if you have skilled advisors involved, then they can give effect to your plan. If you have a plan in place, you have skilled advisors that understand how to put the correct structures in place, etc. And obviously, one of the main benefits of having an estate plan is to ensure that the estate is administered in a professional, prompt and efficient manner. We often find that if an estate is not documented and planned effectively, then the effective execution in terms of promptness is not conducted, in the sense that it could take several years before an estate is wound up, and this creates huge social upheaval and social issues among the family members. So why create wealth when, if you can't communicate the transferal of that wealth to your family members, then it, instead of it being a source of happiness for your family members, it becomes a source of discord and social issues with your own family members. So we need to think very carefully that if we are creating wealth, that we should ensure that our assets are structured in a way where we communicate a proper Sharia compliant estate plan to our heirs also. Next slide. So what are some of the mechanisms in terms of succession planning, inheritance, etc.? Now, I will just discuss this in brief before moving on to the next slide. Essentially, we have a will. Now, a will, let's discuss the issue of a will. According to Sharia, there is great importance and urgency attached to the documentation of a will. In fact, Abdullah bin Umar radiallahu ta'ala anhu, famous Sahabi, has mentioned that it is not befitting for a person who has an asset to bequeath that they do not document their will for more than 2 nights. And this hadith appears in Sahih Bukhari, hadith number 2587. So this shows the importance of documenting a will. Now, when it comes to documenting a will, there are a few important points to note. The first is that the testator and 2 witnesses have to ensure that the will is properly signed off and documented. Now, the witnesses cannot be beneficiaries of the estate, and this is according to English law. So it's important that if you are documenting a will, that you use proper advisors to make sure that the will is also legally compliant. One is that it could be Sharia compliant, but it should also be legally compliant so that it is not disputed at a later stage. What we often find is that, an owner, the individual that has created the wealth, spends much time in creating the wealth. But when it comes to the issue of documenting a will, of creating an estate plan, then they are extremely lax regarding this matter. So it's extremely important that if you are documenting a will, that you ensure that it is Sharia compliant, number 1, and number 2 is that it is legally compliant. And also, there are certain specific requirements of the witness who documents a will. The witness should not be under the age of 14, for example, in South African law. In other countries, it may be different, but there are certain specific requirements of a witness that documents a will. If there is any addendums to the will, an addendum to a will is referred to as a codicil. So the codicil or an addendum to a will has to also be documented and signed off and witnessed by 2 witnesses and the testator himself, or the testatrix herself. So a testator refers to a male executor, the testatrix refer to the female executor. Now, let's move on to the next issue, which is the issue of a trust. Now, when it comes to the issue of a trust, there are different forms of trust. We have the inter vivos trust, we have the testamentary trust, etc. And you have a discretionary trust. What is most important is that the trust deed must be Sharia compliant. So a trust is created by documenting a trust deed, which commences while the creator or the founder is alive, where the founder places his assets in a trust deed. It could be a testamentary trust where it has a will, or it could be a trust which is also what is called an inter vivos trust. The trust has to be registered with the master of the court, and a revocable inter vivos trust, it could be used for a transition of assets, and it could also be used to preserve the privacy in an estate. So there are different forms of trust, and you should seek advice from a fiduciary expert in terms of which trust you should form so that it is managed not only in an efficient Sharia compliant manner, but also in an efficient tax efficient manner also. The next important point is the issue of donations. When it comes to donations, how is your donation documented? And an important point here is the wasiyah, that if there is a bequest, remember, cannot be made for an heir. It appears in a hadith of Tirmidhi, ala la wasiyat riwarith, that behold, there is no bequest for an heir. So in the hadith of Tirmidhi, you can't make a bequest for an heir. In other words, that you cannot make a bequest for an heir. So if you are providing a donation, you are doing a charitable donation or a dispensation, then you should ensure that that charitable dispensation or donation is also in line with the Sharia law. Lastly is in terms of retirement policies. In terms of retirement policies, what is the construct of the retirement policy, etc.? Who has that policy been ceded over to? In certain instances, a retirement policy doesn't belong to the estate itself, because it could be an involuntary retirement policy, and then it constitutes a gift from the side of the state to the nominated heir or beneficiary of the deceased. So that also needs to be looked into. And this generally applies to a form of an involuntary pension fund, for example. Nevertheless, let's move over to the next slide. Now, let's discuss in brief in terms of an introduction to inheritance or mirath. Sharia has accorded great rights to every single individual, whether it be male or female. And the sources of Sharia law includes the Quran, which is the holy book, the Sunnah, Ijma and Qiyas, consensus, and analogy. In other words, that if there is a matter that has not been documented by the previous scholars, and nor does it appear in the two primary sources, that is the Quran and the Sunnah, then we have what is called a Qiyas or analogy. So Qiyas and analogy is applied. So these are the four primary sources of Sharia. And you also have the secondary source, which could be a form of ijtihad or inference or juridical inference in certain matters. Now let's take a few steps back. In Jahiliyyah, in the pre-Islamic era, females and cognates were excluded from inheritance. Descendants were preferred over ascendants. And marriage in general was conducted as a form of prestige for a male. And in actual fact, in certain instances, marriage was actually part of inheritance. So if an individual passed on, then his wife would also get inherited by certain heirs also. So this was an extremely unjust system. So Islam came to rectify the system. And if we look at the pre-Islamic era or the era of Jahiliyyah, you had what is called camaraderie in arms. In other words, that if two tribes got together and they decided that they want to have this comradeship, or they would have a pact between themselves, then that pact could also include inheritance. And one member of one tribe could inherit the wife of another member of another tribe. So this, again, is an unjust system. In fact, there was also the issue of confederation in inheritance. In other words, that one person says to the other that we are now confederates in an alliance, and this will also include inheritance. In other words, that if one person in the confederation passes on, then the other person can inherit his wife also. So when Sharia came down, when the Quran was revealed, then very specific verses were revealed regarding Islamic inheritance, mirath, succession planning, and fiduciary planning, etc. And these verses are recorded in verses 11, 12, and 176 of Surah Nisa, in which very specific guidance is provided as to who inherits what. In accordance with Sharia, we find that agnates and cognates also benefit from inheritance. The female is granted rights in Sharia from an inheritance perspective, although it is half of a male, but nevertheless she is still granted a right of inheritance, as opposed to in the pre-Islamic era where there was no inheritance for the female. So Islam provided certain laws that came to address the unjust system of the period of Jahiliyyah or the pre-Islamic era. Now let's move over to certain contemporary issues, and then we'll open up the discussion for question and answers. So the first issue is with regards to marriage in community of property. Now, there are two forms. One is community of property, and one is the anti-nuptial contract. The anti-nuptial contract. Community of property refers to where an individual gets married in an association in which both the spouses own 50% of the assets in the marriage. This is not Sharia compliant because according to Sharia, if you are the owner of an asset, then you only have the ownership rights over that asset. Second is the issue of an ANC contract. If you have a community of property, or you have married in a community of property, then you should dissolve the community of property and make an application according to South African law, according to Section 21 of the Matrimonial Act of 1986. In other states, there will be different laws where you can make an application to the court to change the construct of your marriage to an anti-nuptial contract, or what is termed as an ANC contract. If you do not document your will according to Sharia, then you will die what is termed as interstate. Interstate means you will die and your assets will be dissolved according to the law of the land, not according to Sharia law. So therefore, it is extremely important, especially for Muslims living in non-Muslim states, to ensure that their wills are documented according to Sharia law. Another important contemporary issue is that of a life policy. Many individuals pay premiums for a life policy, and when they pass on, the issue is, can they benefit from the life policy or not? So the answer is that they can only accord the proceeds of the life policy to pay off taxes and other costs, but they cannot use or directly benefit from the proceeds of a life policy, because that would be impermissible. However, they can benefit from the capital of the life policy, which means that if a person paid premiums of, let's say, $1 million for $100 million policy, then the heirs can benefit of the $1 million capital or premium that was paid for the life policy. Secondly is with regards to the issue of illegitimate children. Can illegitimate children receive inheritance? So the answer is no, they cannot, because Sharia only accords rights to legitimate children. What happens in the instance if there are no heirs? So if there are no heirs, then the assets of the deceased will devolve to the Bayt al-Mal or the public treasury. This is in the instance where there are no heirs. Lastly is with regards to the issue of a gift and donation. Now, according to Sharia, when it comes to gifting of assets, for example, residential property, etc., then a gift is only concluded through possession, which means that if you have to gift someone to an item to another person, then that person has to take complete ownership and possession of the item in order for the gift to be effectuated. So if an individual said to someone that I'm gifting you this item, but that person didn't take possession of it, then the gift is not concluded and the asset would have been deemed to be part of the deceased and subsequently the estate. If there is a particular donation that was made, then the donation can only be bequeathed for up to 1/3 of the estate, up to 1/3 of the estate, and a donation can only be made for a non-heir. So remember this again, that a donation can only be made for a non-heir. So these are some of the contemporary issues that we've discussed. What we will do now is open up the floor for question and answers. And we will then proceed. So if there are any questions, please pose your questions. You can also pose live questions.
Thank you so much, Ismail, for enlightening us as well. What is your experience in terms of wills and dealing with inheritance, over the last few years in South Africa or elsewhere?
Look, my general experience is that people have they do have some sense of understanding in terms of the fact that they need to document their will and it has to be according to Sharia laws. But when it comes to the specifics around issues such as bequeathing a portion of the estate to an heir in terms of gifting, certain technical matters like a life policy, bequeathing the usufruct of, let's say, an estate property, people don't generally have an understanding of that. So this is where we have certain issues. But nevertheless, what we are seeing now is that people are questioning these things, especially when it comes to the development of a trust. I have many doctors, many professionals. In fact, just before this webinar, I had one scholar approach me in terms of how to document a waqf trust or an endowment trust to ensure that his works are preserved and they are continued even after his death. So, I mean, obviously with the COVID-19 pandemic, people have begun to realize, why it's so important to document a will, to have a proper, endowment trust or foundation, if we may call it that. So there is a resurgence, but we need a lot more education around this. Not so much as far as, the importance of whether we should document a will or not, but as far as some of the technical issues, as I mentioned, regarding a gift, regarding donation, regarding how to document a will. I mean, a simple thing like documenting a will, I was actually astounded that most wills today are not even documented legally. So in other words, that beneficiaries of an estate, they are witnessing the will, whereas that is not legally compliant. Or a testator is not, or a testator or a testatrix, they are not properly appointed legally. So you need to get the master of the court, to document these things. And I came across a case recently where the parents passed on, but one of the children, happens to be living in the house of the parents. And the issue came about in terms of, okay, so, what did the parents say in terms of bequeathing what to this heir that happens to be staying in the house? And I said, in terms of this instance, the parents cannot bequeath anything for any heir, even the heir that is living in the house. So all the items that are in the house belongs to the estate, and the heir that is living in the house needs to get explicit permission from the estate to use those items, whether it be a fridge, whether it be a stove, whether it be a car. All the assets belong to the estate, so that heir can't even use it. Now, because this matter wasn't documented, it has led to a dispute. And moving from that, just in terms of what an estate plan actually refers to, is that an estate plan is a very clear document that prescribes exactly how matters should be dealt with in the death of a person. Who is in charge, what happens to certain assets, etc. Everything will be done according to the Sharia laws, but who actually has the authority and who has been deputed to manage certain affairs. If that is not properly documented, there isn't a proper plan, then it can lead to chaos. And this is what causes, so many disputes, family disputes, and so many issues in society because of this one matter. So we need to ensure that when it comes to this matter, we work tirelessly our entire lives to develop wealth, to create wealth. What is the point of creating wealth when you can't preserve the wealth? As they say, one is someone can be rich, but one is someone can be wealthy. Richness means you have a lot of money. Wealth means that you are able to preserve the wealth in a manner that can be transferred from generation to generation. So if you can't transfer your wealth from one generation to the next, then I believe that you've essentially failed in your duty.
Good. Well, thank you very much for that. Maybe just one more question. If there's anybody out there that does have a dispute, it wasn't done properly, what can they do? Where do they go? What is the process under Sharia? Is it, they can't go to the, well, I guess you can go to the courts, but can they reach out to somebody like yourself to assist, or what is the process?
So look, when it comes to this, then there's the issue of mediation, arbitration. We call it the Med-Arb clause. So disputes can go to an independent Sharia scholar or a party that can review the matter in terms of Sharia law and apply a ruling. But more important than that is, I always say before any dispute is resolved via a mechanism, that the dispute is resolved through an amicable manner through a process of negotiation. And sometimes we find that elderly people, elderly heirs also, reduce themselves to immature children, where they start to dispute and fight over small minor items. It was brought to my attention that in a recent estate matter, that the children of the deceased were quite elderly and mature. They were disputing over which glass they should take from the house. Now, I mean, do we reduce ourselves to that level of immaturity, or do we rise up to the challenge and say, let's be mature about this matter, let's negotiate, let's give up certain of our rights so that we can settle this matter and move on. Unfortunately, what happens is, we become immature, we don't negotiate, we don't sit around the table, we don't communicate effectively, and then it leads to disputes. And what happens is, when the matter goes to a court of law, then, I mean, we all know what happens there. The matter can take 5 years, 10 years, 20 years. Everyone loses money. In the end, what happens? The estate becomes poorer. And I know of a certain case where one person, out of spite, drained the entire estate with legal costs. Estate worth millions ended up being in the minus. Now, when the estate goes in the minus, then what happens? All the heirs have to pay, because they have laid a claim to say we are all owners of the estate. So if there are 5 heirs and the estate goes in the minus by $1 million, then one heir only, only one heir can't take all of the liability. All the heirs must take the liability. So, if we are being immature about these things, in the end, who benefits and who loses? I think most probably the lawyers benefit, but the heirs are the ones that lose,
Absolutely. Yeah, I agree with that. Well, thank you very much for that. It doesn't look like we have any more questions. As always, if the webinar will be shared afterwards, and if there's any more information required, please feel free to reach out to either to Mufti Ismail or to us, and we can see if we can help you in the future. Ismail, thank you very much for participating and leading this again, as always. And I hope to see you and speak to you again in the near future.
Thank you very much. I mean, always good to have you online, and we'll be in touch.
Thank you so much. Have a good day.